SJC-11159, Reading Co-op Bank versus Suffolk Construction Company.
No, I have one. Let's proceed.
Good morning, Your Honor. May it please the court. My name is Robert Popio. I'm here representing the appellant, Suffolk Construction, and with me is my partner, Paul Ricotta. As you know, this case comes before you after a jury trial in which the jury found partial liability on 2 counts, a contract count and a UCC count, and was permitted to calculate actual loss with respect to the party on count 1, the contract count.
This is a somewhat stupid question, but just as a practical matter, let's just say, I'm just trying to figure out how these 2 counts work together. If there was no appeal, would the bank, would the contract damages get subsumed into the larger UCC damages?
If there were no appeal?
Yeah.
If there were no appeal...
In other words, you don't get to recover both under counts 1 and 2.
Oh, under the judge's ruling, you do.
Well, that's what I couldn't figure out.
Neither could I. The facts are identical for both counts.
No, I understand your substantive argument, but it's whatever it was, $3 million plus the...
Plus the $533,000.
Okay.
And that $3 million was 6 times the amount of the actual
No,
loss.
I understand that, and that's really what you're here for.
Well,
but I was
as you
just
know,
trying to figure out
the facts are fairly well stated. The bank would not extend a line of credit without having the contractor agree to assign the checks due under the contract to the subcontractor. So the contractor became an account debtor by entering into acknowledgement of assignment. The borrower became the assignee, and the bank became the secured party. There was a history here, but the obligation then of the contractor was to send those checks to the bank. And in each instance, the bank would be obligated to take the check, take such amount that was due on the loan, and only such amount that was due on the loan, and pay itself down, and turn the rest over to the
and deposit
contractor.
I take it in the contractor's account with the bank.
That's correct, or just give it to him. But either way, the bank could only take, and the obligation of Suffolk was only on a line of credit on specific checks at a specific time for a specific amount.
But you do agree that under the assignment and the acknowledgement of Suffolk, that it was, and under the UCC, it was to pay the bank directly.
There is no question about it, and we can see that, and that upon that they found liability. Right. The question is damages, not liability, and we have not appealed the liability issue.
Okay. Is there any, that's probably a factual question as well, maybe. So in the end, let's say, in looking at the statute, all the money should have been paid to the bank, and then the bank applies it, right? And then what's left, the surplus, under the statute seems to go back to the debtor, but in this case, of course, the debtor's already been paid, so we're talking about the double payment. In those circumstances, wouldn't it be at least an appropriate argument to assume that you really can't give it to the debtor, hence you give it back to the account debtor?
Yes. What happens here
So what happens now?
That did not contemplate, 405 did not contemplate a situation
But
where
it
there was a
should,
breach. That's why
arguably,
you rely on the other provisions of the statute, 103 and 106, to determine what happens in the event of a breach.
Well, okay. So
Well, but maybe or maybe not. But one scenario would be that the debtor would be essentially a constructive trustee of those funds that really go back to the person who paid it in the first place, Suffolk here, right?
Yes, but the borrower here is not entitled to the funds because the borrower has already assigned the benefit of those funds to the bank. That's the reason why the statute makes clear that you cannot discharge the obligation to the borrower by paying the bank. But indeed, once by paying the borrower, you must pay the bank. But once that is done, of course, there is no obligation to the borrower because the borrower has assigned those rights to a third party.
I was really talking about the surplus part, once the bank has got the money, and it turns out that they only, instead of the 3.8 million, they only really are owed the 1.5, and so then, if they had no costs, then under the statute, they'd give it back, right?
Under the statute, if they owe nothing, the money should come back. They cannot keep the money.
But they don't
And
give
that-
it back to the account debtor, though.
And what has happened here, and I should emphasize this, the contractor here is not a guarantor. The assignment and acknowledgement was not a guarantee. Had he been a guarantor, then whatever is due on the loan is guaranteed. That is not the case here. The contractor is only responsible for the money due at a particular time when the check is issued. If nothing is due at that time, then that entire fund has to go back to the borrower, who would have otherwise been entitled
You
to
just use
receive
the
it.
names, it's going to be easier for me. So we've got Suffolk, we've got Benchmark, and we've got Reading.
Reading.
Or the bank. So the contractor here is Suffolk. The
Suffolk is the
borrower
general
is-
contractor.
And
Benchmark is the borrower.
so when in your last sentence, the money would go back to Benchmark?
But the money would have been due Benchmark in the first instance and would go back to Benchmark.
Why didn't Suffolk do what it was supposed to do?
Well, what happened here is there was a history in which they had done this in the past. First, the acknowledgement and assignment doesn't specify how it goes to the bank. Benchmark had talked to the bank president about picking up the checks and depositing them, and there was no objection. In the past, the first phase of this contract worked the same way. Did Suffolk screw up? Of course, they should have been very careful on something like this, but the fact is they issue these checks directly to Benchmark. That is the reason why they're going to have to make a double payment. Right. They had to pay Benchmark. They now have to pay the bank what the bank lost. They had to pay the contractor who finished the job for the deficiencies. And now, if this occurs, there's a fourth payment to be made of 6 times the amount of the actual loss. There is nothing in the law that recognizes that kind of...
Well, no, let me turn to that then.
Okay.
Section 96073
Correct.
says that, in this case, the bank may enforce the obligations of an account debtor, i.e. Suffolk. How do you read that? Why doesn't that mean upon breach that they can enforce your obligations to have paid them and you didn't do it?
Because they can only enforce it to the extent that there is an obligation to them. And to the extent that there is no obligation, they cannot enforce something. If the loan had been paid, let me give you this example. Under the judge's ruling, if the loan had been paid in full, the judge's ruling would require $3 million plus to be paid. Put another way, let's assume every time Benchmark received a check, they deposited and immediately gave the money to the bank so that there was no loan. The bank got the money contemporaneously. There was nothing deprived. This ruling says you're entitled to $3 million, and that's the direct conflict with 1106, which says that we are applying rules of ordinary damages, and there is nothing that permits special damages or punitive damages. And this is punitive. And that the code is a commercial code. It is meant for ordinary business dealings in a day in and day out basis. It is not meant to be a penal code of the type that is being imposed here.
But your argument is that they are entitled to be in the same position as they would have been had you paid them directly.
Correct.
But if you prevail, based on your argument, that would not be the case, because
the
they would
contrary.
not get a penny for any of the reasonable cost of collection.
Well, first of all, Your Honor, They are entitled to be in the same position, but not a better position, and that's what 106 says.
Right, I understand that.
and
But the
second-
fact of the matter is, it cost them, because you didn't pay them, it cost them a lot of money. They had to try a case.
No,
Jury said
because
it
the
was
court,
zero.
that was determined in the first trial.
But you say that, but I mean, I look at the jury question. They say, of the amount of damages that you give, state the portion which represents the reasonable cost of collection, and they say zero. It didn't say there are no reasonable cost of collection. It just said the 533 does not include reasonable cost of collection. And I guess the judge interprets that to say they found that there were no reasonable cost of collection. But the trial, of course, is going on, and the trial, I would think, would be a reasonable cost of collection. And how are they going to? I assume the attorneys didn't testify to their billing rate or to the cost of trial, so I'm perplexed here as to how they are made whole by your theory.
And they had that opportunity at the first trial to testify as to their reasonable cost of collection, and that jury determined what it was that they were entitled to, and either because of a defect in proof or no proof at all. And so there are two aspects of this, Your Honor. First, our assignment and acknowledgement does not permit attorney's fees, and under the common law, that wouldn't be permitted in the first instance. But the
UCC does.
But the UCC permits it to be collected out of the funds collected. It doesn't permit that be collected from an account debtor unless there's a specific agreement to that effect, and the code says that. So we don't have a specific agreement. So any money that's collected, the bank can first apply that to their cost of collection, and they don't have to turn over that money to the borrower until they recover their costs. That's how it works.
Right, but they were denied that because you didn't pay them the money. They were denied the opportunity to take their cost of collection.
Here's what we did. We paid them each month each time an invoice was, we sent a check to the borrower. The borrower obviously made his payments.
What a benchmark.
We sent it to the borrower benchmark,
Right.
who made his payments. So the bank wasn't denied anything except the 4 out of the 10 checks that showed a deficit at the time they were issued. That was calculated. That's $533,000 and change. And they calculated it to the penny. And they calculated by not only taking the amount that was due, but then they deducted therefrom the amount that the bank used to mitigate the damages, some $400,000 plus that they had in their possession. And they mitigated. What the bank didn't do is mitigate against $750,000 they were holding that was earmarked for this loan as well. And the judge said he would rule on that after trial and took that away from the jury as well as the UCC damages. So we're in a position where, having breached, and we have accepted liability, and we haven't appealed that, we're in a position where suddenly there is an imposition of a extraordinary penal sum upon the account debtor for an obligation that they didn't incur. They didn't agree to pay the loan. That loan went on for another 6 months after Suffolk was off the job.
They did agree they would make the payments to the bank, and they didn't do that.
They agreed
Wasn't
to
that
make the
their
payment to the
obligation?
bank, and all that means is that the bank has a remedy in damages, and those damages are set by 101, by 103 and 106, because they do not displace the common law, and there is not a specific provision that says, here is how your damages are set. So it is set by 103 and 106.
So you just say that 9607A3 simply means, yes, you have a right to go after the bank. It doesn't tell you how you can go after, and it doesn't give you specific performance of the whatever that obligation.
Quite the contrary. That is exactly what that's why I made the point of the guarantee. That is exactly what the bank is contending, that you should get specific performance. Specific performance is an extraordinary remedy only when damages are inadequate. Damages are not inadequate here. And there is no specific provision of how damages are to be computed, so you go back to the general common law.
If part of the reasonable cost of collection is the trial itself, that would make the attorneys in the case witnesses in the case as to damages.
Well, the fact of life is that there are many instances in which attorneys have to provide their cost of collection, their cost of attorney's fees in order for them then to be
Right,
computed.
but generally, generally after the case is concluded before a judge to ascertain it. Otherwise, the jury is, I mean, the clock is running on the bills. You have to then calculate how long trial will be, closing arguments, post-trial motions. Those are all cost of collection. And the jury is supposed to be involved in deciding that?
The jury has to be deciding the damages and cost, and the judge decided that the cost of collection was in this case. That's why he asked the jury. All one has to do, you don't have to put the attorneys on, you can put the bookkeepers on to testify what the time charges were, what the bills were.
And you want to cross-examine as to whether they were reasonably incurred.
Well, that can be done as well, but none of that was done here to try to establish, in this case, this is the case. This is the case that was before him. You can argue as you can that, well, that's an unreasonable way to approach it, but that was a lot. We think that there are several things unreasonable in this case. That may be one of them, but we rely on the contractual arrangement we had, how the payments are supposed to be made, and the law of damages.
Thank you, sir.
Thank you.
May it please the Court, my name is Nelson Apjohn. I represent the Applee Reading Cooperative Bank. With me this morning is my partner, Cynthia Gazzetti. I'd like to start this morning by talking about the Article 9 issue. And the Article 9 issue is, what is Reading's recovery as a secured creditor with respect to the account receivable that was assigned to it from Benchmark to secure Benchmark's debt? Article 9 provides a clear path to that answer. And in our brief, and it may be helpful during this discussion as we go through the section, there's a chart on the first page of the addendum that lists the sections that I'll be talking about. I think that will provide the roadmap that I'm talking about here.
Mr. Apjohn, could you just start by, did you agree with the answer that what you're seeking is both the $533,000 in damages plus interest as well as the UCC damages?
That is not correct, Your Honor. In fact, on footnote 16 on page 30, we specifically say when the UCC judgment is affirmed, we are not seeking contract damages.
So you're just seeking the UCC damages?
Yes, Your Honor, assuming it's affirmed, which we hope it will
Okay,
be.
and can I ask you then to play out what you do if you collect those damages? Let's say that, you know, the judgment, if it were to be affirmed and, you know, Suffolk pays over this amount of money, what does the bank do with it? Because that's not in your chart.
Right. At that point, the first stop is Section 607, which gives us the right to enforce Suffolk's obligation on the account receivable. The fees that Justice Gantz mentioned with respect to the fees for this action, that's covered in Section 607, not Section 608. And that's explained in the comments to 607. I think it's comment number 10. When you're proceeding against a third party, those fees are covered by 607. Fees against the debtor itself, here Benchmark, are covered by 608. So there's a recovery on the collateral. You recover on the account receivable, which is the damage. You're enforcing the account, the amount owed on the subcontract, which has not been paid under 405.
Okay, could you know, could we just be looking at like
608?
yeah, I mean, I'd like to know sort of, I'm having difficulty following with all these UCC code provisions. I'd like to know sort of what the bottom line here is going to be and who's going to get any surplus.
Just go through 608. What happens is that the reasonable cost of collection are first paid out of the proceeds, the amount collected by the bank.
From Suffolk?
Yes. Then the obligation, Benchmark's obligation to Reading is paid, including interest, including late fees.
That's all paid?
That's paid out of the proceeds.
Okay.
Next, any subordinate secured interest are paid. And then if there's a surplus, it goes to the debtor.
And the debtor here is Benchmark?
Benchmark.
So the debtor gets the surplus?
Yes, Your Honor.
Why is that?
Because that's the way the 608 specifically expressly lays it out.
It doesn't go to, it doesn't go back to Suffolk?
No, Suffolk is liable on the entire account receivable under the assignment. Suffolk cannot withhold any of that amount. What it does is it pays it over. It's the proceeds distributed under 608. Suffolk at this point is not even a creditor of Benchmark.
You think that the code in 9608 sub 4, the paying over of the surplus, contemplates a situation like this where the full amount of all the checks are paid to the secured party and then they pay everything out, and let's say Okay, they pay the $1.5 million, and it costs them $500,000, so it costs them like $2 million. So there's $1 million. What's that? What's left? $1.5 million, $1.8 million, whatever it is, a couple of million to the debtor who
That's what you-
doesn't owe it to. Is there something missing here?
What's missing is that a claim was not brought by Suffolk against Benchmark. If you look at the First National Bank of Marietta case, it's a Supreme Court of Ohio case. And what the court says there is that Suffolk's recourse is against Benchmark. And in that particular case, there's a third-party claim, which would be against Benchmark here. And at this point, if that claim was brought, Suffolk would be a judgment creditor. In fact, at that point, it could try to secure that judgment with respect to anything that Benchmark receives in surplus. That has not been done. But that's an easy method of addressing that situation, and that's how the code would work with it with respect to a third-party claim. If you let Suffolk offset in some manner based on this damage theory under a separate contract, the amount that it owes that could go to surplus, what you're really doing is giving Suffolk a status as a preferred creditor. Right now, it has no claim with respect to Benchmark. Nothing's been asserted. Other general creditors of Benchmark would be entitled to those funds when it's paid to Benchmark. And Suffolk doesn't step up as a preferred creditor, which has taken no action to enforce its obligation.
But, I mean, there are many errors that can be made in the world of the Uniform Commercial Code, many breaches of contract, but this is an extraordinarily severe one for this particular screw-up.
And what happened, Your Honor, I think the question was asked earlier, how did this happen? The reason this happened is not because of a course of performance beforehand. What happened is that the account executive who knew about this arrangement left in the summer of 2004, and after that, the people in charge of making the payments didn't realize that these payments had been assigned to Reading. That's what happened.
Right, so I mean, but you
quite
have...
apart from that, I mean, if you have a situation where, let's just assume the bank, which I assume happens some of these times, Benchmark paid off, got the check directly, that was against the, just assume hypothetically then, okay? I assume that if Benchmark got the check, paid some down of what was owed to the bank, but Suffolk had screwed up, as Justice Gant says, because they didn't pay you directly, they actually paid Benchmark. On your theory, the bank would be entitled to the entire amount, even though Benchmark, I'm not saying this happened, but even though hypothetically Benchmark had actually paid down the loan, right?
Yes, the problem is that the account receivable on the bank's book stays at the $3.8 million. So the bank is continuing to lend against the $3.8 million without realizing that Benchmark is taking the money and putting its own account. So when it's lending money, it believes it has a security interest of $3.8 million. And what Suffolk is saying, based on an unrelated contract, the contract where Suffolk agreed to pay Reading directly, that somehow a damage remedy controls Article 9, and it doesn't. That separate contract with Suffolk is not required under Article 9, and it doesn't control Article 9. What you're looking at under Article 9 are the proceeds from collection, and the legislature tells us how those are distributed in 9-607 as well as 9-608.
Why does it not, I mean, you've got this cool hand Luke problem of a failure to communicate, but there's all kinds of failures to communicate which create losses. Here, why does it not make more sense to say you get your damages, you get your cost of collection, and that's it? Why do you have to have the money go to Benchmark and then have them file a separate action against Benchmark and add a whole other layer of litigation when clearly Benchmark shouldn't get a penny out of this? Benchmark should have taken the money, either said to Suffolk, this is wrong, this is not what we agreed to, or if they had taken the money, paid you. So Benchmark is no hero here, but under your theory, they get the money unless we have another lawsuit brought by Suffolk against Benchmark. Why does that make any sense? Why is that a sensible course of business?
Well, first of all, you would not need another lawsuit. What you often see is where, in this particular case, it would have been a third-party claim against Benchmark. There would be a judgment against Benchmark at this point. That was not...
Could you clarify for me, did Benchmark make payments to the bank? That's what I understood your brother to say.
The payments there may have been some payments to the bank, but the payments that came in primarily went to Benchmark's pocket, which allowed them to continue on. They were basically getting money from the bank at the same time they're getting money from Suffolk. So they were getting the double payment for the work that they were doing.
Did they make payments to the bank?
They made some payments to the bank, Your Honor, but the problem was there were other contracts. There was a contract for the base building, and there was a plumbing contract. So when those payments came in, the bank was not aware that those payments were being made. In fact, if they were being made, because they go into a general benchmark account, they were payments from Suffolk on this particular contract. Those payments would have gone to the bank's officer in the loan department, who can then adjust the account receivable downward and would know what the security interest is when they're continuing to lend money. And going back to Justice Gann's question, the problem with the scenario that I think you just proposed is that the legislature says subordinate secured interest also get payment, the third rung down. And in this particular case, if you hold that benchmark or that Suffolk somehow has a priority with respect to the general creditors of benchmark at this point, that's a preference that is not found in Article 9.
I'm not suggesting that they would have a priority. My question is, after doing that, and then they're next, right? The surplus is after paying all those other lien holders and everybody else and themselves. Then the question is, if the only way to get the surplus, let's say there's a $2 million surplus after that, but you say, well, it costs us reasonable fees and attorney's fees, $2 million, or let's say $1.5 million, let's be reasonable. So here, benchmark, you have 500. Where does a litigation take place that challenges whether that's reasonable if that's the only recourse, other litigation, when you decide I'm going to spend it all down, give it back to benchmark, and then say under the UCC, then the Suffolk has to sue
In the First Bank of
benchmark.
Marietta case, for example, you saw
Is that the
litigation.
only case that holds this way?
Well, it's an example of a case where a person in Suffolk's position filed a third-party claim and therefore had a judgment against what would be benchmark here. Here, once you know that benchmark is going to receive a surplus, if in fact it does, I guess you would bring a claim against benchmark for mistake or possibly misrepresentation in obtaining these checks, obtain a judgment, and enforce the judgment against benchmark. And of course, under trustee process, you could probably secure a judgment if you had one. But if a
But
third-party
it would
claim is...
only be with respect to whatever it is that the bank then decided
Right, because
they want to pay
608 lays
themselves
out,
for any
lays
reasonable
out how the
fees, et cetera.
proceeds are distributed.
And so there's no way to
Back
challenge
to the
that.
facts again, just so I understand this. So Suffolk gave money directly to Benchmark. I think your brother said that 6 out of 10 times then Benchmark gave money to the bank?
No, Your Honor. I think there's some confusion on behalf of Suffolk because what he's referring to is the contract claim. What we did, the contract between Suffolk and Reading, what we did is we tried to reconcile that because when the payments came in, if they did come in and they didn't hear, we would only keep that amount if there was a balance at the time. So we basically did a hypothetical reconciliation for purposes of the common law contract claim, but that has nothing to do with the UCC claim because those checks were never paid. That's why the common law contract claim damages are different than the UCC recovery. It was a separate contract, separate obligations, and something that's not required under Article 9. If you took Suffolk's position, the court would actually have to imply a common law contract between Reading and Suffolk to impose their remedy in this case. But that doesn't control the Article 9 recovery. And that's controlled by 608 and 607. And under Section 405, of course, any payments made to benchmark does not reduce the account receivable. That entire account receivable is still owed by Suffolk in this situation.
What if a mistake, I know that that didn't happen here, but what if a benchmark had made a payment to the bank and the bank applied it to one of these other contracts? Is there any remedy under the UCC for that, that kind of misaccounting?
If they applied it to the contract that was subject to the account receivable,
Yeah.
that would reduce the bank's balance, and that would mean that the surplus, if any, would be greater, or the deficiency with respect to what the debtor owed would be less, because the bank's obligation, the second step under 608, would be less.
But I thought that one of the things that you said was that some of the payments that Reading made, or that Benchmark made, had gone to other contracts.
Benchmark was receiving money from Suffolk under other contracts, and so they took that money and they put it in their own account, and whether some of that money actually made its way to pay some of the loan balance off,
I'm sorry, your answer to Justice Spina, if the bank had made a mistake and applied funds not against the account, that would only result in the end of a greater surplus that would go back to benchmark?
If they took the funds that came in and applied it to the contract that's subject to the account receivable, that would reduce the obligation on the contract, and therefore, on the second step of 608, there'd be less recovery from the bank, more of a surplus, less of a deficiency if there's a deficiency.
But in none of these scenarios would there be less due from Suffolk?
No, Your Honor, because under 405, they're liable for the entire account receivable. Again, going back to the Supreme Court of Ohio, what they tell us is that the bank's recourse is against benchmark. When it mispays the payments to benchmark, it takes the risk with respect to benchmark's insolvency or not at that point. And that's the way the code works. And I guess I'm out of time, so at this point I would ask that the court...
You still have 30 seconds. I'm still, your argument that the UCC under Article 607 and 608 anticipates breach and means to cover breach, and yet provides for a remedy that in this case, benchmark, would get the proceeds. Why is that a sensible thing for the UCC to do because whenever there would be a breach, the person in benchmark's position would be a wrongdoer?
Under the 608, of course, covers a lot of different situations. It could cover something where you're not even dealing with an account, but you're dealing with a deposit of $100,000 that secures benchmark's obligation. So that takes account into a lot of different situations of a collateral. But here, there's no reason to, you basically would have to rewrite Section 608 in order to come up with the result that Suffolk advocates. And there's no reason to, because, first of all, in the rules of civil procedure, you could have done it in this very case, but there's nothing to prevent Suffolk from suing benchmark, getting a judgment, and securing that judgment. So when those funds do come in as surplus, Suffolk takes the funds. So there's no reason to adjust Rule 608 or Article 9-608 in trying to accommodate the situation here, because Suffolk could accommodate the situation by filing a third-party claim in this case, in which case it would have been a judgment creditor of benchmark by now, or even taking a separate action against benchmark and getting a default judgment if benchmark's not there to defend itself.
And does benchmark still exist?
Excuse me?
Does benchmark still exist?
Benchmark, my understanding, has been administratively dissolved.
So there's no so where does the money go now?
Well, I think what would happen is either it gets
Not to
revived to deal with other creditors, including Suffolk, if it becomes a creditor, because it's not at this point. There's a judgment I know out there with respect that would have to be satisfied that we have notice of. And if anything, where funds are left without ownership or being claimed, I believe they go back to the Commonwealth. It's not a situation where the bank
So
gets
in
a
this
win.
situation, Suffolk would not get a penny.
It can still make a claim. Bring a claim against benchmark, it would have to be revived to do so, but bring a claim against benchmark to enforce its rights either for mistake or, again, misrepresentation, which could have been done earlier.
All right, sir. Thank you very much.
Thank you.